You are driving home from work. You have not done anything wrong. You have not broken any traffic laws. You have not done anything that should put you on anyone's radar. But out of nowhere, a patrol car signals you to pull over. You see the flashing lights in your mirror. Your heart rate spikes immediately. Your mind starts racing through everything you can think of that might have triggered this. You expect the officer to walk up and say something about a tail light or a rolling stop, or maybe a lane change that was technically close. But instead, the officer walks up to your window. You roll it down, and the very first thing he does is lean slightly toward the opening and say, "I smell marijuana." What do you say? What should you do? Is there anything you can actually do to protect yourself in that moment? And more importantly, can you stop officers from using this claim to get into your vehicle when they have nothing else to go on? Most people freeze entirely. The panic takes over. And in that moment of panic, they either say the wrong thing, something that the officer logs as an admission, or they do something with their body that gets interpreted as a furtive movement, and suddenly the officer has exactly the additional justification he needed to proceed further. The Supreme Court has addressed the legal framework around this exact scenario in multiple decisions. And by the end of this video, you are going to know the exact words to say, the exact traps to avoid, and the precise legal standards that govern what officers can and cannot do when they claim they smell marijuana at a traffic stop. Subscribe right now, because this is exactly the kind of information you need before you are already in the situation. Let us get into it. Let us start at the constitutional foundation, because everything that follows only makes sense if you understand what the Fourth Amendment actually says and what it actually means in practice at a traffic stop. The Fourth Amendment to the United States Constitution says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. In plain language, a police officer cannot rummage through your pockets, your car, your home, or your belongings without a legally sufficient reason to do so. That legally sufficient reason has a name. It is called probable cause. Probable cause means an officer has enough specific, articulable facts in front of them to lead a reasonable person to believe that a crime is being committed or that evidence of a crime will be found in the place to be searched. Think of it this way. If you walk into your kitchen and see smoke coming from the stove, you have probable cause to believe something is burning. You can see the evidence. The conclusion follows from observable facts. But there is a lower standard that is even more important to understand for traffic stop situations, and it is the one that most people have never heard of until something goes wrong. That lower standard is called reasonable suspicion. Officers only need reasonable suspicion to pull you over for a traffic stop in the first place. Reasonable suspicion is a meaningfully lower bar than probable cause. It requires a lesser amount of evidence, a specific articulable reason to believe criminal activity may be afoot, not that a crime has been committed, just that it might be occurring. And this distinction between reasonable suspicion and probable cause is exactly where the smell of marijuana becomes legally significant and legally dangerous for most drivers, because officers are trained to use the initial reasonable suspicion of a traffic stop as a platform from which to fish for the probable cause they need to go further. Here is the trick that plays out in traffic stops every single day across the country. The officer pulls you over for a legitimate or pretextual traffic violation. They have reasonable suspicion that gets them to your window legally, and then they lean in and say they smell marijuana. If the smell claim is accepted as probable cause, it unlocks the vehicle search. Everything that happens next flows from that one statement that you cannot verify, cannot disprove in the moment, and cannot challenge until you are already inside the legal system, dealing with the consequences. This is why the marijuana smell claim has been used for decades as a master key to get into vehicles, because it is a probable cause claim that a driver cannot immediately counter with evidence, and that courts have historically been willing to accept. That landscape is changing, and the Supreme Court and state courts across the country have been drawing new lines around when and how the smell claim can be used. Understanding exactly where those lines are in your state is the foundation of protecting yourself. And there are 3 questions you need to work through the moment an officer makes this claim. The first question is whether marijuana is legal in your state. This single fact determines more about your legal exposure than almost anything else in this scenario. In states that have legalized recreational marijuana, courts have been significantly and consistently more skeptical about whether the smell of marijuana alone constitutes probable cause to search a vehicle. The basic logic is straightforward. If possessing marijuana in your car is no longer a crime, then the smell of marijuana in your car does not indicate the presence of contraband any more than the smell of alcohol would. You can smell like something legal. The presence of a legal smell does not establish probable cause for criminal activity. Maryland provides one of the clearest examples. Courts there ruled in 2020 that the odor of marijuana alone is not sufficient to establish probable cause to search a person. By 2023, that protection extended explicitly to vehicle searches as well. If you are in Maryland and an officer claims they smell marijuana and moves towards searching your car on that basis alone, you can say clearly, "Officer, I am aware that odor alone is not sufficient to establish probable cause for a vehicle search in this state. I do not consent to a search of my vehicle." Ohio followed a similar path after recreational legalization in 2023, with courts finding that smell alone is no longer sufficient probable cause and that officers now need observable evidence of impairment to justify extending the stop. Colorado ruled back in 2019 that even drug-sniffing dogs trained to alert on marijuana cannot use that alert as probable cause without additional supporting evidence. But if you are in a state where marijuana remains fully criminalized, like Texas, the legal landscape is substantially different. Texas still treats any usable quantity of marijuana as a misdemeanor subject to potential arrest. Courts in Texas have generally been willing to accept an officer's claim of marijuana smell as probable cause for a vehicle search. If that is your state, you need to understand that the smell claim is going to be used aggressively and repeatedly, and your protections in the moment are significantly narrower. The second question is whether the officer is claiming burnt marijuana smell or fresh marijuana smell, because this distinction carries real legal weight, and it is one that experienced officers know to navigate carefully. The burnt odor of marijuana is a lingering smell. It can attach to clothing, to upholstery, to the interior surfaces of a vehicle for hours or even days after the marijuana itself is long gone. If you sat next to someone who was smoking at a party 4 hours ago, you might carry that smell into your car. If someone smoked in a rental car you picked up at the airport, that odor might still be present when you return it. The burnt odor of marijuana is extremely difficult to tie directly to current active possession of marijuana inside the vehicle. Courts have recognized this, and defense attorneys routinely use it to challenge the probable cause justification for a search based on burnt odor alone. The fresh odor of marijuana is a different matter. Courts have generally been more willing to accept fresh marijuana smell as evidence that marijuana is currently present in the vehicle, because fresh smell does tend to indicate proximity and current presence in a way that burnt odor does not. Officers who understand this distinction, and many trained officers do, will often walk up to your window and say something ambiguous like, "Do you smell that? What is that smell?" Or, "I am not sure. Does that smell like marijuana to you?" That is not a neutral question. It is a technique designed to get you to provide the characterization they need. If you say, "Yeah, that smells like marijuana," or, "Yeah, I was around some people who were smoking," you have just given the officer something that is far more useful to them than their own claim would have been. You have become your own witness against yourself. Never characterize any smell for an officer. If an officer asks what something smells like, your answer is, "I prefer not to answer questions. Safer and made, nothing more." The third question is whether the smell claim, if accepted as probable cause for the vehicle as a container, automatically extends probable cause to every person inside the vehicle. The answer, established in the Supreme Court case United States v. Day from 1948, is that it does not automatically extend. Under that ruling, probable cause established in connection with a vehicle or container does not immediately and automatically transfer to the passengers inside it. The vehicle is treated as the container. The driver is presumed to have custody and control of the container. The passengers require separate independent probable cause based on their own circumstances. So, if an officer smells marijuana and uses it to establish probable cause for the vehicle, they still need something specific about each individual passenger before they can search those passengers or compel them to exit the vehicle for investigation. What does that mean in practice for passengers? It means that if everyone in the vehicle exercises their constitutional rights, stays calm, keeps their hands visible, and does not make statements or movements that give officers additional ammunition, the officer's ability to act against against the passengers is severely limited. Officers know this, which is why they will typically separate the occupants of the vehicle immediately, getting the driver out first, and then having another officer approach the passengers separately, hoping that at least one person will say something useful. The entire strategy depends on someone talking. If nobody talks, the officer has to build their case from observable facts alone, which is a much harder assignment. Now let us talk about the two Supreme Court loopholes that allow officers to extend this situation beyond what most drivers understand their rights to cover. The first is the pretext stop. The Supreme Court case Warren versus United States established that officers can follow a vehicle, observe a minor technical traffic violation, use that violation as the legal justification for a stop, and then investigate for something entirely different. The traffic violation is the pretext. The real purpose is the drug investigation. The Supreme Court ruled this is constitutionally permissible even when the officer has no genuine interest in the traffic violation itself and would never have written a ticket for it in any other context. This means that if an officer believes a vehicle may contain drugs, they can follow it until a tail light flickers, a tire touches a lane line, or a turn signal activates a fraction of a second late. And that observation becomes the legal basis for the stop that then becomes the platform for the marijuana smell claim that then becomes the probable cause for the search. The chain is built on a traffic violation that nobody would have cared about if drugs were not the target. The practical protection against the pretext stop is maintaining your vehicle in legal condition and following every traffic law with technical precision when you believe you may be being followed. Signal every turn early. Stay cleanly within your lane. Maintain a speed that does not create even a marginal justification. If an officer is following you looking for a reason, deny them one for as long as possible. And the moment they pull you over, despite your technical compliance, stay silent from the first word. Do not offer explanations. Do not answer questions about where you are coming from or where you are going. Hand over your license and registration and nothing else. The second loophole is the canine hold, and the Supreme Court has specifically addressed and limited this one in Rodriguez versus United States. In that case, the court ruled clearly that a traffic stop cannot be extended beyond the time reasonably necessary to address the original reason for the stop without independent reasonable suspicion of additional criminal activity. This means an officer cannot legally tell you to sit on the side of the road for 20 minutes while they wait for a drug dog to arrive, using only the original traffic violation as justification. Once the purpose of the stop is complete, meaning the ticket has been issued or the warning has been given, you are legally entitled to leave. And if the officer wants to hold you longer, they must be able to articulate specific, independent, reasonable suspicion that goes beyond the original stop. That independent suspicion cannot simply be the smell claim they already made because they have already used that. It needs to be something new and separate. This is why asking a specific question at a specific moment is so powerful legally. The moment an officer hands you a ticket or a warning, you say, "Officer, am I free to go or am I being detained?" That question puts the status of the stop on the record. If you are free to go, you leave immediately. If the officer says you are being detained, they are now on the record claiming they have independent, reasonable suspicion sufficient to hold you, and that claim will be scrutinized in court. If they do not have it, the continued detention and everything that flows from it may be suppressed. Now let us talk about the two behavioral things officers look for to supplement a smell claim and how to neutralize both of them. The first is nervousness. Officers are trained to note and report nervousness as a contributing factor to probable cause calculations. Trembling hands, voice changes, excessive sweating, avoiding eye contact or making too much eye contact. These all get logged as indicators of consciousness of guilt. The Supreme Court has not been impressed by this argument, and neither have many lower courts. In United States versus Sukalo and subsequent cases, courts have recognized that nervousness during a police encounter is a nearly universal human experience that tells you very little about whether a specific person is committing a specific crime. The court in United States versus Milan stated explicitly that being nervous is not a reliable indicator of criminal behavior, but officers continue to log it because it adds to the cumulative picture they are building. And most people do not know they can push back on it. If an officer tells you that you seem nervous, you say, "Officer, I am trying to remain calm. I do not consent to any search." That is it. The second is furtive movement. This is the claim that something about the way a person moved, reached, shifted position, or reacted suggested suspicious activity. Courts across the country have been fairly consistent that a furtive movement alone, without additional supporting evidence, is not sufficient to establish probable cause. In Gonzalez versus State, a Texas court ruled that a furtive gesture without more was not sufficient to justify a search. The problem is that officers know that people will make nervous movements during a traffic stop, and they are trained to characterize those movements as suspicious. The best protection is to keep your hands visible on the steering wheel from the moment you pull over and to narrate any movement you make before you make it. My license is in my wallet in my back pocket. I am going to reach for it now. My registration is in the glove box. I am going to open it slowly. This narration eliminates the furtive movement claim because every action is anticipated and explained before it occurs. If an officer accuses you of making a furtive movement, you raise your hands clearly where the camera can see them and say, "Officer, I did not reach for anything and I am in compliance, but I do not consent to any search." Sasandan. Clear, calm, and on the record. Now, let us talk about the exact words for 3 different scenarios where the marijuana smell claim might come at you because the scenario changes what you say. First, if you are in your car during a traffic stop and an officer claims they smell marijuana, you say this officer, "I am familiar with the law in this state regarding odor as probable cause. I do not consent to any search of my vehicle. Am I free to go or am I being detained?" You do not elaborate. You do not explain. You do not discuss what you think the smell is or is not. You state your non-consent. You invoke the Rodriguez framework by asking about your status, and then you stop talking entirely. If officers come to your front door and claim they can smell marijuana from the porch, you have an even stronger position because your home receives the highest level of Fourth Amendment protection. You do not open the door. You speak through the closed door and you say, "Officer, do you have a warrant? May asatang." If the answer is no, you say, "Then I am invoking my Fourth Amendment rights. I will not open this door without a valid warrant." And then you do not engage further. If they claim things will get worse if you do not cooperate, that is a manipulation technique and not a legal statement. They cannot make things worse by your refusal to open your door to a warrantless search. Your silence and your closed door are your rights in action. If you are simply walking on a public street and an officer approaches claiming they smell marijuana on you, you are in what the law calls a consensual encounter. In a consensual encounter, you are legally free to simply keep walking. The officer has no more legal authority over you than any other stranger on the street at that moment. If the officer steps in front of you and tries to stop your movement, you ask immediately, "Am I being detained or am I free to go?" "Nay." If you are not being detained, you continue walking. If the officer says you are being detained, they have now asserted that they have reasonable suspicion to temporarily stop you, and that claim will need to hold up legally. At that moment, you say clearly, "I do not consent to any search, and I am invoking my right to remain silent." Then you stop talking. Across all 3 scenarios, the golden rule is identical. Never consent to a search. Those 4 words, "I do not consent," are the most powerful legal statement available to you in any of these situations. Giving consent to a search is like handing someone your house keys and then being shocked when they open every drawer. Consent cures all from the officer's perspective. It eliminates every constitutional challenge you might otherwise have. Every judge, every defense attorney, every legal expert will tell you the same thing. Whatever happens in the moment, no matter how intimidating the officer becomes, no matter how certain they act about what they are going to find, no matter how much they suggest that cooperation will make things easier for you, do not consent to a search ever under any circumstances. Here is your complete framework. If an officer claims they smell marijuana, know your state law on whether smell alone constitutes probable cause. Know whether the claim is burnt or fresh, and never characterize the smell yourself. Keep your hands visible and narrate your movements. State clearly that you do not consent to any search. Ask whether you are free to go or being detained. If detained, invoke your Fifth and Sixth Amendment rights. Stay completely silent and get an attorney involved before you say anything else to anyone. Most people who lose these encounters do not lose because the law was against them. They lose because they talked. The officer's claim of marijuana smell is not a conviction. It is a starting point. What you do in the next 60 seconds determines what that starting point leads to. You now have the Supreme Court cases, the exact words, and the complete framework. Use them. Check out the next video on this channel where I break down the 10 lies police are legally allowed to tell you and exactly how to recognize them before they work on you. See you there. AI features. Feedback. Transform your transcript with AI-powered insights. Search AI features. Output language. AI responses will be in this language multilingual content creation most used. Your top 5 features based on usage. No favorites yet. Start using features and your top 5 will appear here automatically. Popular features. Summary. Comprehensive overview. Key insights. Main takeaways. Clean transcript. Remove filler words. Proper notes. Comprehensive notes. Basic content. Summaries and transcripts. Analysis. Deep insights and patterns. Study and education. Learning and note-taking tools. Content creation. Social media and blog content. Specialized. Advanced analysis tools. Generated content. AI-powered outputs from your transcript. Click any AI tool above to generate content here.